The book itself is a kind of report from the front, insofar as it's dealing with the argument that people make that we shouldn't refer to what goes on abroad. It just says, this is what we do, and it isn't even that controversial. Look at the nature of how our docket has changed during the 21 years I've been there. More and more cases come up that require us to know quite a lot about what happens beyond our shores. And I've categorized them and explained why and so forth. But why you bring up that case, which is a very, very interesting, it was a woman, Dolly Filartiga. She was not in the Supreme Court. She was from Paraguay. She came to New York about sometime in the 1970s. And there in New York, she discovered the man from Paraguay who in Paraguay had worked for the dictator and tortured her brother to death. She also found a statute that had been passed almost 200 years before, the Alien Tort Statute, and it had been passed probably in part to help victims of pirates. And it said, she said, that I can bring a claim for damages in a federal court. And she did, and she won. And she went back to Paraguay saying, I came to the United States to look that man in the eye, and I came away with so much more. Well, as a result of that, many cases brought. Many. I mean, all kinds of questions raised. He, Stroessner, the dictator of Paraguay, is not and was not the only human rights abuser in the world. And the Marcos's victims brought cases in Hawaii. There are many cases. And it falls to the federal courts to interpret this statute. And it's not as easy as you might think. Who are today's pirates? Moreover, what happens when South Africa, as they did, files a brief in the federal courts and says the problem of dealing with the victims of apartheid and the perpetrators is a problem that we are dealing with through Truth and Reconciliation Commission. And we don't want American federal judges interfering. When do we interfere, and when do we not? And how do we get this statute to fit within a network of statutes that exists throughout the world so that we don't work at cross purposes, cancel each other, and in fact cause more trouble than we're helping? Hard questions. I mean, do we want to have an interpretation that will in fact allow Belgium to begin to bring proceedings against, everyone uses this as an example, Henry Kissinger, all right. Probably not. I mean, maybe some do, but nonetheless. You get the nature of the problem. Universality, non-interference. You cannot interpret this statute, as we've tried to do on 2 or 3 occasions, without looking into the questions of where does this fit with the International Criminal Court, for example. Where does it fit with a host of other laws? That's just a human rights area. That's one example. There are other examples. Commerce, civil liberties, security, treaties. There are dozens.